File 24-21967-FH, People of the State of Michigan versus Deontay Laquan Dill. We're here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record.
Isaac Sneed for the people.
Once again, good morning, Your Honor. Raymond Burkett on behalf of Mr. Dill. And Mr. Dill, would you identify yourself to this honorable court?
Yes, Deontay Dill. Good morning, everybody.
Okay, thank you. And Mr. Burkett, where do we stand with Mr. Dill's case today?
Well, Your Honor, right at this particular moment, I've tried to work out something with the government, with the prosecutor, and that has failed. So what I'm thinking I'm going to have to ask this honorable court to do is to set a final conference date and probably a trial date. And hoping that something will be worked out by the final conference date. Because at the final conference, I'm sorry.
I'm sorry, go ahead.
You got kind of blocked out on me on my screen. At the final conference date, I did tell this honorable court that it was going to be my intentions to file a motion to quash.
All right, how much time do you need to file your motion to quash? Because I'd like to have that filed, heard, and resolved before a final pretrial conference.
Oh, okay. I thought we were doing this. Not a problem, Your Honor. I can do it the latter part of January. I have two capital cases going the first part of January, so I can't do it then. But either the latter part or the first part of February, I can argue my motion.
Okay. Why don't we set it for a pretrial then on January 31st? I'm sorry, that's not it. I got the wrong date. Give me one second.
January 31st?
I'm sorry, January 29th.
Give me just one brief second, if you, Your Honor. January 29th, Your Honor, is a good day.
Okay, so we'll set it for a pretrial on that date, and you can file and have your motion heard on that date as well.
Okay, I will do. At what time?
That would be 8:15 a.m.
Okay. Now, Your Honor, one final question on the motion. Will you allow it to be done by Zoom, or do we have to appear in person?
You can do that by Zoom.
Thank you very much. Your Honor, I won't get a chance to tell you until afterwards, but I hope you have a good holiday.
Thank you. You too. Mr. Sneed, is there anything we need to address from the people's side?
No, thank you, Your Honor.
Okay, so we'll set it for a pretrial and a motion hearing on January 31st. Depending upon what happens with that motion hearing, I'd set it for a final pretrial and a trial at that point.
You said the 31st. You do mean the 29th, don't you?
I'm sorry. Yeah, I apologize. January 29th at 8:15.
Okay. Thank you very much. And once again, have a good holiday.
Okay, thank you to you too. And Mr. Burkett, Mr. Dill, you can go ahead and log out then.
Thank you. Have a good day, sir.
Mr. Goldstein, do you need to speak to Mr. Simmons?
No, Your Honor.
Okay.
Got him on phone and
All right, we are on the record then in file 19-19648-FH 23-21368-FH and 24-22017-FH. People versus Antoine Lamar Simmons. We are here today for arraignments on probation violations in the 19-194648 case and the 23-21368-FH, and for a hearing on a contempt for violating bond conditions in the 24-22017-FH file. First, can I have the attorneys place their appearances on the record, beginning with Mr. Hartung?
Thank you, Your Honor. Good morning. Doug Hartung, appearing for the people today.
David, excuse me, David Goldstein, appearing on behalf of the defendant.
All right, and Mr. Simmons is present from the jail. Sir, you are Antoine Lamar Simmons, correct?
Yes, sir.
Mr. Simmons, have you received the probation violation warrants in the 19 and the 23 case?
I believe so. Was that Thursday?
Those were filed yesterday.
No, sir.
All right. Is there an officer there with you that you can ask to get you a copy of the warrants?
Yes, sir.
Okay.
She said she's calling.
All right. While they are getting those to you, Mr. Simmons, I will let you know that the warrants both allege the same thing. They allege one technical violation for, they each allege two technical violations for possession of controlled substances with intent to deliver. One count being possession with intent to deliver cocaine, the other intent to deliver heroin, and one non-technical violation. The arrest for possession with intent to deliver was a violation of criminal law, which would be a non-technical violation. The technical violation is just possession of controlled substance. In the 19-19648-FH case, you were convicted of one count of assaulting and resisting obstructing police officer. The maximum possible penalty for that offense is up to 4 years in prison. You were also convicted of one count of delivery or manufacture of cocaine in that case, and the maximum possible punishment for that offense is up to 20 years in prison. In the 23-21368-FH, the warrant alleges the same probation violations, and in that case, you were convicted of larceny by conversion with a habitual offender third offense notice, making the maximum possible penalty in that case up to 10 years in prison. With respect to the 24 case, those are the violation of bond conditions, which we discussed, I believe, last Thursday and adjourned to today. You do have the right to be represented by an attorney with respect to these probation violations and any hearings that we have on them. Mr. Goldstein, are you going to be representing Mr. Simmons on the probation violations also?
Yes, Your Honor.
Okay. And do you know how Mr. Simmons wants to plead with respect to the probation violations?
He's going to stay in mute, ask the not guilty plea be entered and matter be set for trial.
I will enter not guilty plea for Mr. Simmons. And do you want to set that for trial now, Mr. Goldstein?
Your Honor, I do. Mr. Hartung can speak to this better than I can. The problem with conducting a hearing, given the nature of what the allegations are, my anticipation is that there are going to be criminal charges filed. They were not filed as of yesterday, but Mr. Hartung can probably speak better to the status on those.
Sure, they are pending at this time, and I suspect they will be issued in the next during this week. I suspect they'll be issued.
So well, Your Honor, what I'd like to do, and I know it's a little unusual to ask this, but can we do a pretrial and a violation hearing just to see what this, like I said, it's going to be hard to conduct a hearing in this matter when I got criminal charges pending against my client. So
Yeah, I understand the difficulty of that position, given the potential for new charges. So when would you like, how far out do you want me to look to I can set it on a Wednesday and we can see where things stand.
Well, Your Honor, I don't want to go out too far, but the problem is I know 2 of your Wednesdays are the holidays. And I don't know if you're using other days those weeks or you're just going to pass those 2 weeks, but
So if you run a green folder, the fund count. Yeah, so the 25th and the 1st are both holidays, obviously. So let me, I'm getting some other dates, Mr. Goldstein. I'll see if I can find a day other than Wednesday that we can figure that out. Otherwise, it would be January 8th would be the first available, unless you wanted next week, which would be the 18th.
well, Your Honor, I'm not sure, again, what the status of the criminal case
Yeah.
will be that quickly, but I assume Mr. Hartung is right. It'll be this week. I expected them yesterday, but we don't know.
Okay.
Let's set it for next week just to see where we're at.
So next week's going to be December 18th at 8:15.
Now, Your Honor, once we set that, there is one question that I have. When he was arraigned last week, you set a bond of $25,000 cash or surety. The jail has it as cash only. We need to clarify. And my understanding is that bonds have to be either cash or surety, that's required.
So I believe the bond amount was $100,000, not $25,000.
I'm sorry. I meant 100,000. Yeah, I'm sorry. But the jail has it as cash only. And my understanding is that that's not proper, that it has to be cash or surety.
These is warrants on the current charges.
Okay. Mr. Hartung, anything you'd like to say with respect to the bond issue?
Well, I think the other part of this is what's going to happen with the charge he has not been sentenced on yet. There was a PR bond on that case. I believe the court has set $100,000 bond of some nature on the contempts and perhaps the violations. But right now I think he's technically on a PR and not receiving any credit on that other charge.
Okay.
My understanding, Mr. Hartung, was he set the bond on all the cases, but I could be wrong about that. I didn't look.
No. So what we've got right now is when we were here last week, we were here on the one warrant, which was the violation of bond conditions. And that warrant had a $100,000 bond on it. So with respect to the underlying charges right now, he would still have the PR bond. So I think Mr. Hartung's correct on that. With respect to the two new warrants for probation violations, there's currently no bond on those.
I don't have no paper saying nothing about no new charges. This say larceny by conversion and this say R&O or something like that.
Yeah, and what you have there is warrants for probation violations on those old cases that you're on probation for those. And your probation officer has gotten a warrant for violations of probations, which are related to the same allegations as the contempt warrant in the 24 case.
Okay, how did I,
So-
if I
I'm sorry?
if I violated probation, why I don't see nothing. How did I violate probation?
I've explained that to you on the record, Mr. Simmons, and it's in the warrant.
Sir, I done been taken to the sheriff's department, been strip searched, everything. So how am I violating? I done been released from the sheriff's department. I done been released from the same day. So how am I in violation? They let me go. They let the lady go. Everything. Like they let her drive off in the car. They took me to the sheriff's department.
All
Released
right,
me.
so Mr. Simmons, I'm gonna stop you there because we're not trying the case today. And you have potentially new charges against you, new criminal charges that are going to be filed against you. And so anything that you're saying right now can potentially be used against you in any one of those cases. So Mr. Goldstein, then what, if anything, are you requesting with respect to the bonds at this point?
Well, Your Honor, you set a bond of 100,000 on the one case. I'm asking that that be made for all the cases, but make sure that it's cash or surety also. But we're asking for 100,000 for all the cases.
Mr. Hartung, anything further you want to say about the bond issue?
I think the court has set the bonds appropriately. You know, the whole idea of getting him out on that PR bond was to see if he could stay out of trouble. And obviously he's had some difficulty accomplishing that at this point in time. And I think there's probably going to be some additional bonds set on the new criminal charges when they are issued the next few days.
At this point, Your Honor, there, as the court knows, they're allegations. They have not yet been proven.
All right, I am aware of that. So I will check on the cash or surety issue. If in fact I'm required to make that cash or surety, that's what I will do on the contempt warrant bond. On the underlying file, the underlying file in the underlying charges in the 24 case, I will set a bond on that of $1,000 cash or surety. I'm leaving no bond on the violation of probation warrants. And the reason that I'm doing that is that, as I explained last Thursday when we were here, Mr. Simmons is on probation in the 19 case. He has several probation violations in that case. He's on probation in the 20 case. He has a probation violation in that case. He is pending sentencing in the 24 case, which involves delivery or manufacture of controlled substances, 2 counts of delivery or manufacture of cocaine, heroin, or another narcotic. It also involved a host of other charges involving felony firearm, possession of firearm by a felon. And he has now been arrested and is likely receiving new charges related to again, possession with intent to deliver controlled substances. And so at this point, think that the bonds are appropriate where they are because of the concerns with continued criminal activity on the part of Mr. Simmons. So that's what I'm going to do with respect to the bonds.
So
Thank
what's
you,
gonna
Adam.
happen if these bonds, what's gonna happen if these charges is not true?
Then you'll be found not guilty and released.
You know what I'm saying, so I don't get a bond for an allegation like these is clearly allegations that is not true. How did I get
I'm
released
not-
from the sheriff's department? And like, come on, man, like y'all can't be serious. How did I get released from the sheriff's department and being charged with a possession? Possession means I have something on me.
We're not going to argue this further today, Mr. Simmons.
Oh man, like for real, bro. Shit is getting out
You
of
can let the
hand.
officer know that you're done with court.
Your Honor, what date did you adjourn this to?
Next Wednesday, sir.
Oh man, this shit not even law, man.
Thanks, David.
So no bond.
All right, I placed Mr. Simmons' device in the waiting room, and I'm going to let the jail know that he's done with court. He wants to continue to argue the issues, and I'm not going to do that. Okay, Mr. Bagley, are you ready to proceed with Ms. Kester?
But we are, Your Honor.
1 second. Okay, this is file 24-21964- no, I'm sorry, wrong case number. I'm sorry, so 23-21366-FH, People versus Holly Sue Kester. We are here today for a pretrial conference in this case and proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Your Honor, Patrick Bagley on behalf of defendant Holly Kester, who is with us here today.
All right, and we're here for a pretrial conference today. So Mr. Bagley, where do we stand with Ms. Kester's case today?
Well, Judge, I think we need a trial date for mid to late 25. And I'd like to address with the court. We submitted a demand to discovery to the prosecutor's office back on September 24th. And I'm not trying to, rat out the prosecutor by any means, but we still have not received any response. And we did submit a proposed order to provide the discovery. I'm hoping the court is able to, consider that and possibly sign that today. We are going to need quite a bit of discovery from the prosecutor in order to try this case. It's becoming it's kind of taking on a life of its own and becoming a behemoth. So we started out, Judge, this case was going to take probably 2 weeks to try. It's now going to take a full month. We have approximately 70 witnesses.
All right, so we adjourned the case last time for you and Ms. McClure to discuss the length of the trial. Did you have that discussion?
Judge, we have not in person. We plan on getting together in person after the holidays to go over more. But in our oral exchange, we're thinking this is going to take a month.
Mr. Sneed, do you have anything from the people's side?
Our file indicates we did receive a discovery demand September 26th, and there was an answer to discovery request provided to defense counsel on that date as well. If there's a different one out there, I'll speak with Ms. McClure and have her review the file before speaking with counsel. But other than that, I have nothing further, Your Honor. Thank you.
Mr. Sneed, I know that you're not the lead on it, but with all due respect, I don't remember seeing a response from the prosecutor's office on behalf of that. But I can look again. It's quite possible I might have missed it.
Thank you.
Do you know, Mr. Sneed, is Ms. McClure in agreement with the trial needing a month of time?
It's noted in the file that was defense counsel's request, but I don't know her position. I suspect if we receive a 70 witness list, there may be some pretrial motions to address that. So based on my experience of looking at this case, a month doesn't seem ordinary. Thank you.
Okay, Ms. McGrain, what do we have on the calendar available for a 4-week trial in mid to late 2025?
Judge, after the summer, because we do have various holidays and vacations scheduled during that time, that would break up a month. You have another 4-week trial beginning September, right after Labor Day, September 2nd, continuing through October 15th. So I'm not sure if you would want to wait until perhaps November to allow for other matters to be scheduled for a couple weeks and then go into another long trial.
I'm sorry, you said the Warner trial goes through the 15th of October?
The final day is the 14th, so
14th?
I'm not sure what deliberations will look like, but
All right, why don't we start looking then in the first part of November?
we could start Tuesday, November 4th and continue on absenting Veterans Day. And then, of course, the Thanksgiving holiday.
Okay, so to get those couple of days back, we would need to go through December 5th, essentially.
That is open, Judge.
I'm sorry, that was November 4th
Yes, Judge.
was the start date? Through December 5th. So let's set a final pretrial for October 22nd. At 8:15.
Judge, you said 10:22?
Correct. With respect to the discovery issue, I don't know, it sounds like maybe they've responded, maybe they haven't. So Mr. Bagley, I'll leave it to you to figure that issue out. And if a motion needs to be filed, you can do that.
Thank you, Judge.
Is there anything else we need to address today?
No, thank you, Your Honor.
So Judge, we're blocking out November 4th through December 5th for the trial?
That's correct.
Thank you, Your Honor.
The court will send out a scheduling order with the trial dates and final pretrial date in it.
Thank you, Your Honor.
Okay. Thanks, then you're all set. You can go ahead and log out.
Thank you, Judge. Jerry, hold on one second.
Mr. Daly, are you ready to proceed?
Yes,
Mr. Rogers. It's file 24-22019-FH, People versus Scott James Rogers. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
James Daly, being a matter defendant.
And Mr. Daly, where do we stand with Mr. Rogers' case today?
We have not yet been able to resolve this matter, but as to have the matter set for trial, Your Honor.
Okay, and how long will you need for a trial? It's 1 day.
1 day.
Ms. McGrain, can you give us a 1-day jury trial date for People versus Rogers?
Judge, would you like that as a firm date or a backup?
What was that?
Any preference on having a firm date or a backup date?
No,
Let's go with a backup date.
We could do Thursday, February 20th. It would be backed up to Robert Clement.
what was that date in February?
Was that February 20th?
Actually, the following day, the 21st, is open. It wouldn't be a backup.
Okay, why don't we put on the 21st then, if that date works for everyone?
Okay.
So 21st, February 21st. For trial, and let's do a final pretrial on February 12th at 8:15. Okay, is there anything else we need to address with this case today, Mr. Daly?
No, Your Honor.
Anything else, Mr. Sneed?
No, thank you, Your Honor.
Thank you, then I think you're all set.
Thank you, Your Honor.
Thank you. Mr. Glazer, who is that you have in your office with you?
Give me a call right after.
This is Mr. Byer, Your Honor.
Okay. This is file 24-21994 FH People versus Jeffrey Lynn Byer. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the People.
John Glazer on behalf of Mr. Byer.
All right, and Mr. Daly, where do we stand with Mr. Byer's case today?
Did you say Mr.
I'm sorry,
Daly?
Mr. Glazer.
Your Honor, he's going to plead guilty to a misdemeanor. He's supposed to pay restitution, and if he does, there would be no upfront jail. I don't know how the court wants to do it, if it wants to take the plea, but he thinks he's going to need 60 to 90 days to pay the 50. I think it's around $1,500. We don't have an exact figure on it.
Okay, so I don't have an amended information, so I don't know what misdemeanor you would be pleading to.
Oh, it'd be a 1 year.
Mr. Sneed, is that accurate?
That's been part of the discussion, Your Honor. If you'd like to give us some time this morning, I'm sure we can reduce it to writing so we could proceed with the plea this morning if you'll allow that.
Yeah, okay. We can pass it for now until you have the documents we need.
Thank you.
Okay, thank you, Your Honor.
Mr. Murphy, are you ready to proceed with Ms. Kately?
Your Honor, I think I'm gonna have to ask if we could wait on that unless, because I was asking Mr. Sneed for something unless he wanted to adjourn, or if he thinks he can figure it out this morning. I guess I'll defer to him.
It's the same thing. All we got is
Because there was a plea worked out on the previous file. There was a newer file. We're trying to get understanding of what's going to be encompassed with this new file. So that's what we're waiting on.
Yeah, Your Honor, I'm not prepared to address that offer at this point. Again, if you'd like to pass the matter, we can have some time to review the files Mr. Murphy's referencing.
All right.
Thank you, Your Honor.
This is Judge Olsaver calling. Could we see Matthew Higgins in the Zoom pod? I don't have jail pods logged. Okay, that was my bad, sorry. Okay, thanks. Okay, I have the jail Zoom 2 pod. All right, Mr. Mawad, do you need to speak to Mr. Higgins?
Make sure they can hear you before I walk away.
I don't know if you answered Mr. Mawad, but you were muted.
Sorry about that, Judge. I can hear you.
Do you need to speak to Mr. Higgins?
No, Judge, we did talk to him several days ago. Thank you.
Okay. So this is file 24-21964-FC, People versus Matthew Virgil Higgins Jr. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Your Honor, good morning. Elias Muad appearing on behalf of Mr. Higgins.
All right, and where do we stand today, Mr. Muad, with the case?
Judge, thank you. Ms. Arnold and I did talk. We just are getting a large volume of a download of some phones. Ms. Arnold and I talked. Our thoughts, if the court would accept it, is to set one more pretrial in February, I think, Ms. Arnold. And then if you have to set it for trial, Judge, because you have to put this on the book somewhere, we would say March. I can't tell you it's going to trial. We're just waiting to do our due diligence on the phones.
Yeah, Judge, our request, so the victim is in school and we'd like to be able to try it over the summer months if possible. I think we're probably going to need 3 days, 4 days, maybe.
Yeah, and again, Judge, once I get down with the due diligence, I can probably talk to Ms. Arnold about hopefully a resolution. I just want to give her a very thought processed statements and letter to her regarding this case. And I know where she stands already on the case with some offers, but I'd like to just give her my thoughts as I usually do, and then try to come up and resolve the matter.
Okay.
Yeah, the only reason I would want to potentially lock in a trial date is if we can't, if we come back at the beginning of February, if it looks like we could still sneak in a trial date over the summer, I think, Mr. Mawad, and I think there's a decent chance of resolving the case, but I really would like to try it over the summer when the victim's not in school, if we could do that.
Yeah. If that's the case, it would probably be best to set that trial date today, given the way the calendar seems to be filling up. So I'm sorry, you said, Mr. Mawad, 3 to 4 days. Is that what I heard?
I think Ms. Arnold said that. I don't necessarily disagree with that.
Okay, so Sierra, could you find us a 3 or a 4 day jury trial date in June or July?
When does school get out?
I think the last day of school is June 6th, I believe.
Okay, we could do Tuesday, June 24th. The remainder of that week is open.
That'd be great.
That's fine. And Mr. Higgins, this doesn't mean that we're not going to try to resolve it earlier. Okay, so I know you're in jail, and I just want to let you know that he's got to set a trial date to keep everything going. Okay.
Okay, thank you.
Okay, so the 24th through the 27th. And then you wanted a pretrial date in February?
Yeah. So I think my boss, my wife, set up a trip somewhere in February. I'm just not sure. February 13th of the 20th, I think. So I don't know if you want to do it or second week of Feb or the last week of Feb, but whatever works with Ms. Arnold and the court.
So the first Wednesday in February would be the 5th. The second Wednesday would be the 12th.
I would take the 5th. Will
Okay.
that work, Allison?
The 5th is good for me.
Okay.
So February 5th. 8:15 for pretrial. And then let's use June 11th at 8:15 for a final pretrial, if you both have that date available.
Yes.
I'm trying to set a trip to Europe this summer. I'm not sure about the dates, but I'm sure we could move a final pretrial if we need to. That looks good so far.
Yeah, you don't have to worry about me.
So we'll use that for now. If it becomes a problem, we can adjust that as necessary.
Okay.
Okay, anything else we need to address with this case today?
Judge, do you want us to do an order on the dates, or do you take care of that? How would you like to do this for dates in order?
I'll do a scheduling order with all those dates in it, and we'll send it out to you.
Very much appreciate it. Matthew, I'll be in touch with you. You know where we're going with it. Thank you. Thank you, Allison.
Yeah, thank you. Take care.
Thank you.
Okay, Mr. Higgins, you can let the officer with you know that you're done with court for today.
Thank you, sir.
Okay, Mr. Malero, are you ready to proceed with Mr. Getz?
Yes, I could be ready, Judge.
Okay, he is here on Zoom. Okay, this is file 24-22003, People versus Joseph Douglas Getz. We are here today for pretrial conference in this case, and we are proceeding today partially by Zoom and partially by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Joseph Getz.
And Mr. Malero, where do we stand with Mr. Getz's case today?
Your Honor, Mr. Getz had a misdemeanor down in district court that was recently resolved with a different counsel. So I'd ask to adjourn this matter one time so that I could get together with the attorney assigned to this case, prosecutor, and see if we could get this matter resolved as well.
Mr. Sneed, anything we need to address from the people's side?
No, thank you, Your Honor.
All right, so I can adjourn it to January 8th at 8:15 if that works.
Yep.
Thanks.
And Mr. Malero, would you do that step in order?
Yes, I would.
Okay, so Mr. Getz, your next date is January 8th at 8:15 a.m. You can log in using all the same Zoom information you used today.
All right, thank you, Your Honor.
Okay, you're all set. You can go ahead and log out.
All right, thank you.
And Mr. Malero, are you ready for Ms. Bocor?
Yes, I'm ready.
Ms. Bocor, can you hear me? Oh, there you are. Are you? So we're not able to hear anything that she's saying.
Can you hear us, Heather? Shake your head, yes. No, okay. You can hear us.
I don't know if you want to proceed under those circumstances, Mr. Malero, or if you want me to wait until we can hear her if she has anything to say.
I think,
looks like we may have
I think
fixed
she's on, Judge.
Okay, I got it.
Okay, I think we're all set then, so. We are on the record in file 24-21970-FH.
Oh my gosh, now it went
This
out.
is Heather Marie Bocor. Can you hear me, Ms. Bocor?
Yes, can you hear me?
Yeah, we can hear you all right.
Okay.
So first, let me have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Salvatore Malero on behalf of Heather Bocor.
Okay, and Mr. Malero, where do we stand with Ms. Bocor's case today?
Judge, I'm going to ask to adjourn this. The basis of my request is she has a case down in district court that I think requires more attention, and once that's resolved, this matter would get resolved. So that's the basis for my request.
Mr. Sneed, anything that you would like to address from the people's side?
We have no objection to that request, Your Honor. Thank you.
All right, Mr. Malero, how long do you anticipate the district court issue to take?
I've been in touch with a detective on that, Judge. Probably 30 days, I think, given the holiday situation. I maybe need a little extra time.
Okay, so let's go with January 22nd at 8:15.
It works great, Judge.
And then would you do that stip and order also?
I would.
Time to reflect on why we celebrate that holiday. And so maybe you want to use it as a way to just bless the community and have families, be able to take part in something.
Okay, anything else we need to address with that case?
Not on my end, Judge.
No, thank you.
And it's just
Okay, so Ms. Bocour, your next date is January 22nd at 8:15. You'll log back in using all the same Zoom information you used today.
Okay, thank you.
Thank you, Judge. Thank you.
Like you have to do. Do you think that this could be a good way for people to?
So I had a second place for this. Now this is. And my other place is this is on my son. So this is he's 12.
Morning, Judge.
Ready? Okay.
All right, Mr. Davis, I do have Mr. Jacobs in a Zoom pod at the jail. Do you need to have a breakout session with him?
Yes, please.
Okay, 1 second.
Thank you.
Okay, so Mr. Murphy, I'll send Ms. Hennigan here. Are you ready to proceed with the Flores cases?
I guess so, Your Honor. I don't know. I haven't seen Mr. Flores. I don't know if they're zooming in or not.
Got one device here.
They are.
Without a name. All right, we've got a device logged in as Samsung SMX1518U. Can you tell me your name?
Carly Frank.
Okay, 1 second, Ms. Frank. All right, Ms. Frank, I'm going to put you back in the waiting room for just a minute. I'll get to your case next.
Thank you, Your Honor.
They have me. Yes. Okay. All right, I have a device logged in with the screen name Skylar. Can you unmute the device and tell me who you are, please? There's a device logged into the meeting. Your screen name is Skylar. I've sent you a request to unmute your device. I need you to unmute your device, please. I'm not getting any response from that device. Mr. Murphy, I don't know if you want to proceed now or try to get a hold of Mr. Flores.
We've already tried. The number that we have isn't good for Mr. Flores, so we can't delay it any further. It's gonna matter from my end anyway.
All right. So we're on the record in file 24-21845-FH and also file 24-21886-FH. People versus Raymond Flores is the 845 case. People versus Emily Flores is the 886 case. This was originally scheduled as a final pretrial conference today. First, let me ask the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Matthew Murphy, appearing on behalf of Raymond Flores.
Samira Hennigan on behalf of Emily Flores.
All right. This was set for a final pretrial today at 8:15 with the trial starting December 17th. I did communicate with the attorneys last night. There is a motion pending to quash the information and dismiss the case. We've heard oral argument on that as the court got into preparing an opinion and order on the motion. Some additional questions came to mind that weren't briefed and I think deserve some briefing in terms of making a decision on that case. And so I notified counsel last night that we would be vacating the trial date, and I'm going to enter an order hopefully today, letting the attorneys know what those issues are on which I intend to request some additional briefing on the motion. I guess the other issue is that neither Mr. Flores or Ms. Flores are present here today. This was set for 8:15. It's 9:25 now. Mr. Murphy, is there anything you want to say about that issue?
No, Your Honor, I think I've already expressed to the court. I do apologize for it. There's, I guess, an issue with having the correct number for Mr. Flores, so we apologize for his absence at this time.
Ms. Hennigan, anything you want to say about Emily Flores or her presence today?
Thank you, Your Honor. I would just say that in the past, Ms. Flores has always showed up for her court dates. We have had an issue with contacting her as well. And I do find that Ms. Flores, unfortunately, is easily confused about the purpose of court dates. So I'm concerned that maybe she thought that the last hearing had changed something and we wouldn't have to have a pretrial today, and maybe didn't understand that there's no ruling on that motion yet. But she's never appeared for her court hearings before, so I apologize on her behalf, but I would like to waive her appearance for today if the court will allow, and we continue to attempt to get in contact with her.
I will say that we're both here in person for the motion hearing that we had a few weeks ago. Not aware of any prior failures to appear in the file. What I'm inclined to do at this point is to set another final pretrial date and a trial date. So we have that back on the books, and then we'll get the issues resolved with respect to the motion to quash it before the next trial date. So did we have it set for 2 days?
I think I did, Your Honor. I think I requested that. We could probably just do a 1 day, because I think these hearings are hammering out the issues that I would have extrapolated upon that, so I think maybe 1 day would be sufficient.
Okay. Are you in agreement with that, Ms. Hennigan?
Yes, Your Honor.
So Ms. McGrain, I guess we'll need a 1 day trial date in perhaps February if we have something available.
So Wednesday, February 19th is open.
I'm available on that day.
Your Honor, I would just defer to the court schedule by February. There'll probably be another conflict attorney assigned for this case.
Okay. So we'll go with February 19th then, and a final pretrial February 5th.
Your Honor, if I discussed it with my client and I guess also Mrs. Flores and her attorney, whoever it will be, if we wanted to waive a jury trial and proceed with a bench trial, would the court want notification by a certain date of that? Again, if the people were in agreement with that as well? Or is that would be this date? Because at this point, I'm not sure that that's something that we may consider. I just haven't spoken with him about it at length.
So why don't we schedule it I'll schedule it as a jury trial right now. If something changes, we can address that at the final pretrial minutes.
Thank you, Your Honor.
I think that'll be sufficient. All right, anything else we need to address today?
No, thank you, Your Honor.
Nothing further for myself, Your Honor. Thank you.
Okay.
No, thank you, Your Honor.
Okay, thank you then. I think we're all set.
Thank you, Your Honor.
And the person logged in is Skylar. Your device is now unmuted. Can you tell me who you are?
Yeah, this is Skylar.
Can you tell me your last name?
McCollum Rosa.
Okay. Your attorney is with Judge Anslem right now, so I'm going to place you back in the waiting room until she gets logged in here, okay?
Alrighty.
Mr. Davis, are you ready to proceed with Mr. Jacobs' case?
Judge, almost. I had a conversation with my client. The offer in this matter is 48 months. The client is considering taking the offer. I'm wondering if the court, if he does take the offer, 48 months, he doesn't have any prior criminal history, no prior incarcerations. He has some things that he needs to get in order in his life before he's gone for that long. So he would just ask the court, if he does accept this offer today, to consider allowing him to be released prior to sentencing, and then he'll come back for sentencing so that he can get his things in order, his property, his home, his pets, and things like that.
All right, well, let me call the case before we get into that discussion.
Okay.
So this is file 24-21919-FH, People versus Andrew Frederick Jacobs. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Mr. McCready.
Dave McCready for the people.
And good morning, Your Honor. I'm Maurice Davis, P76203, appearing with Andrew Jacobs, who's present appearing via Zoom. Mr. Jacobs, state your name.
My name's Andrew Jacobs.
All right, and we had started a discussion off the record with respect to the possibility of Mr. Jacobs entering a plea and a request for a bond modification. Mr. Davis, is there anything further you want to say about that?
Yes, Your Honor. There is currently an offer on the table of 48 months. My client is considering the offer. I'm asking the court, if he does decide to take the offer, would the court be willing to modify his bond so that he can get his things and get his affairs in order prior to being sent to prison? He has property, he has pets, just some things that he needs to kind of wrap up, get together, and then he'll show up for sentencing. He's always showed up for his court dates. So if the court would consider that, I believe we'll be prepared to move forward. I will have to have another breakout room with my clients just to go over the factual basis and his trial, his rights and everything. But we want to know if that's an option first.
Mr. Mr. McCready, where would the people stand on that request?
Well, to be clear, the offer is a minimum sentence of 48 months on count one, possession with intent to deliver, but he'd also be pleading to the felony firearm, which is an additional 2 years consecutive. So he's looking at a substantial prison sentence. And, while he has been out on bond, he hasn't exactly followed the court's orders. He has appeared, I agree, but now he would be facing an imminent sentence. So we do have concerns about his appearance at that point.
All right, so looking through the file, Mr. Jacobs has 5 contempts, all related to failing to test or using controlled substances. Under those circumstances, I would not at this point be willing to modify the bond conditions or allow him here to be released.
Okay. Understood. Let me have a chance to speak with my client and see what's to proceed.
Okay, I can put you back in that breakout session.
Thank you.
Mr. Amadeo, are you ready to proceed with Ms. Frank?
We are, Your Honor. Thank you.
Okay, so this is file 23-21418-FH People versus Carly Lynn Frank. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me have the attorneys place their appearance on record, beginning with Mr. Sneed.
Isaac Sneed for the people.
Good morning, Your Honor. William Amadeo, P7619, for on behalf of Ms. Frank. We both consent and appreciate the appearance on Zoom. Carly, please state your name for Your Honor, his staff, and the people to know it is you on Zoom.
Carly Frank.
Yeah.
Okay, Mr. Amadeo, where do we stand with Ms. Frank's case today?
Your Honor, I believe we were working towards a resolution. Ms. Frank did reach out to me today. She's been in the hospital. I've been trying to have communication with her. The prosecutor on the case has suffered some tragedy, obviously, and I was having good communications with her. I do not know if Mr. Stee is going to be taking over the file or if Ms. Mears coming back. I would ask for a couple-week adjournment to try and get to the goal line if there's no objection from the people.
No objection, and Ms. McClure will be back.
And Judge, I'd like to give her time so we could, obviously she has bigger things to worry about, but I would like to have intelligent discussions with her. And I want to respect her wishes right now.
Okay, let's go with an adjournment to January 15th, if that date works.
We'll make that work. Thank you, Judge.
15th at 8:15 a.m. Mr. Amadeo, would you do a stipulation in order for that adjournment?
Yes, Your Honor, I'll complete that now. Mr. Steed, may I have your permission to sign your name?
Yes, please.
Okay, and Carly, please call me today. Thank you, Judge.
Okay. Thank you. Thank you, Your Honor.
Okay, so Ms. Frank, next date's January 15th at 8:15. You'll use all the same Zoom information that you used to log in today.
Okay, Your Honor. Thank you.
Have a good day, Judge. Thank you.
Okay, are we ready yet on Mr. Byers' case?
If I could have one moment, Your Honor, I'll check in on that amended information.
Okay.
I have an opportunity to speak to the prosecutor.
Mr. McCready, can you do a breakout session with Mr. Davis?
Yeah, that would be helpful.
Okay, let me set that up.
Your Honor, we should have that amended information over to the court in a couple minutes.
Okay. Can you email that directly to me? Kelly is not here today. So
Yes, Judge.
Judge, are you talking about a plea agreement?
yes.
All right. If they could email it to me as well, that would be wonderful.
Okay.
Okay, we're back on the same page, the prosecutor and I. Can I speak with my client?
Your Honor, I think we're ready on Ms. Kaylee whenever the court's ready for the case.
Mr. Sneed, are you ready for Ms. Kately's case?
Yes, Your Honor.
Okay. So we are on the record now in file 24-21833-FH and 24-22053-FH. People versus Taylor Lee Kately. We're here today for pretrial conference in both of those cases, and we're proceeding today by partially by video conference and partially in person. First, can I have the attorneys place their appearance on record, beginning with Mr. Sneed.
Your Honor, we have Isaac Sneed and also Douglas Hartung on behalf of the people.
All right, yeah, I'm sorry. Mr. Hartung indicated he was on the 21883 file. So Mr. Hartung, you want to place your appearance on the record on that one?
Yes, thank you, Your Honor. Doug Hartung also appearing for the people today.
Okay.
Matthew Murphy appearing on behalf of Ms. Kately. Your Honor, we had a plea agreement that I was discussing with Mr. Hartung involving the 883 file, and there was a misdemeanor that was downstairs. The newer file came up that was assigned to Ms. McClure. We're trying to figure out ultimately what can get resolved with that file with the plea on the other file. We're asking for an adjournment today because of that. Ultimately, there's too many moving parts, and with her absence, we're just gonna ask for an adjournment if the court be okay with that. And then there's a misdemeanor that's downstairs that we're gonna adjourn as well. But yeah, that's what we're asking for today, Your Honor. Hopefully, we'll have this resolved before the next pretrial in front of Your Honor.
Anything to address from the people's side?
No, thank you.
No, we're all set. Thanks.
All right, so let's go with January 22nd then at 8:15.
Yes, Your Honor.
Mr. Murphy, would you do stipulation and orders for those two files?
Yes, Your Honor.
Okay, anything else we need to address today then?
Nothing further from the defense, Your Honor. Thank you.
Okay, thank you then. I think we're all set.
Thank you, Your Honor.
Thank you, Your Honor.
Is he in back?
Yes.
Okay. Thank you. Has Mr. Colin Rose up in it?
He's on Zoom.
He's on Zoom?
Yeah.
Okay. I think I'm gonna go get on my, or I think we can take care, or no, I'll get on my device. Do you wanna do Bradley or,
Whichever you want to do first.
why don't I do Mr. McCollum Rosa first?
Okay.
I'll go get on my device.
Okay. All right, I have an amended information now for Mr. Byer. Are we, let's see, plea offer just showed up, so we'll print that as well.
Okay, we're ready, Your Honor.
Judge, if I could address the court, I just noticed that the Adobe PDF plea offer had some language cut off of it during some conversion. I'm going to email the Word document to you and Ms. Teskey and Mr. Glazer right now.
Okay.
I got a complete one, Isaac, unless it's more than 2 pages.
Okay, thanks.
All right, so let's see, we are back on the record in file 24-21994-FH, People versus Jeffrey Lynn Byer. And we do now have documents related to the plea agreement. So let's see, Mr. Glazer, do you want to state your understanding of the plea agreement? Then I'll ask Mr. Sneed to confirm.
Yeah, Your Honor, I don't have the amended information, but I assume there's a count 2 on there that's retail fraud 2nd degree, which is a 1-year misdemeanor. He's going to plead guilty to that count with the understanding that there would be no upfront jail at time of sentencing. He is to make restitution by sentencing, and I believe it's in the amount of right around $1,500 if he doesn't make that restitution, the plea could be withdrawn, and then the offer would be he'd have to plead to a felony. So we'd ask the court to take his plea and set the sentencing for April 1st. That's when this is supposed to be completed by.
Okay, Mr. Sneed, is that complete and accurate statement of the plea agreement?
Yeah, I would just add, I think paragraph 5 states the defendant's waiving his right to a restitution hearing if the restitution is calculated at under $3,000, which, however, we do suspect it's around $1,300 or $1,400.
Okay, 1 second.
Correct.
All right, Mr. Byer, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury.
I do.
And you are Jeffrey Lynn Byer.
Yes.
Mr. Byer, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 second-degree retail fraud?
Yes.
And do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $2,000 fine or 3 times the value of the property that was stolen, whichever is greater?
I do.
Are you satisfied with Mr. Glazer and the advice he's giving?
Yes.
Other than as we've discussed it on the record here today, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is.
Mr. Glazer?
Yeah, as long we placed on the record, I assume that there'd be no jail as long as restitution's made by sentencing.
Yes. And is that also your understanding, Mr. Byer?
Yes.
If a guilty plea is accepted, Mr. Byer, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Byer, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I understand.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
I understand.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
I do not.
Do you understand that you're giving those rights up?
Yes.
How do you want to plead to the charge that on or about March 8, 2024 in the city of Hudson, County of Lenawee, that you did commit the offense of second-degree retail fraud?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that weren't disclosed to the court on the record today, or that it was not your own choice to enter that plea?
I understand.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Byer to plead guilty today?
No, Your Honor.
Mr. Sneed, I did not hear your response.
Sorry. No, Your Honor.
Thank you. Mr. Byer, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record this morning?
No.
Is it your own choice to plead guilty?
Yes.
Sir Glazer, do you want to cover the factual basis?
Yeah. First of all, Mr. Byer, you understand that you're pleading to a retail fraud second degree, which is a 1-year misdemeanor.
I do.
And part of this plea agreement is that you got to make restitution by, and I think the judge is going to give us a sentencing date, but we'll find out of, it's got to be done by April 1st.
Yes.
And we, looking at the police report, we think it's around $1,400 bucks.
Right.
And you understand if you don't make that payment by that day, the prosecutor can ask to have it withdrawn, and then the best they would offer you would be a felony retail fraud.
Understand.
Okay. Is it true that on or about March 8th of this year, you were here in Lenawee County in the state of Michigan?
Yes.
And did you steal some batteries?
Yes.
And those where were those are from a store here in Adrian, or
Hudson.
in Hudson?
Yeah.
What store was that?
Bob's Market House or Market House. I think it's Market House.
Okay. And those batteries were for sale to the general public, is that correct?
Yes.
And they had a value of at least 200, but under 1,000, is that correct?
Right.
But you understand that in reality, that's just a plea. You could be ordered to pay restitution beyond 1,000. You understand
Yes.
that?
Yes.
Okay. I don't have any other questions, Your Honor.
Mr. Sneed, are the people satisfied with the factual basis?
I am, Your Honor. Thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor. Thank you.
Mr. Glazer?
Yes, it has, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Byer has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed it on the record here today. I will refer this matter to the district court probation office for a pre-sentence investigation. And we can set sentencing for April 3rd at 8:15 a.m. So, Mr. Byer, you'll need to report to Michael McCarran in the district court probation office. That's on the first floor here in the courthouse this coming Tuesday, December 17th at 8 a.m.
On Tuesday, you go see the probation officer. We're not gonna be back till April 3rd. Get that money paid.
Yes.
All right.
So when you do, Mr. Byer, when you do your pre-sentence investigation interview with Mr. McCarron, please be truthful about this offense and about your background.
Be truthful and honest
Yes,
about your.
yes.
Okay, so you're all set, and then again, your sentencing date is April 3rd at 8:15.
Thank you, Your Honor. Have a good day.
Thank you, Your Honor.
Thank you, Mr. Glazer.
All right.
What is today, 11? Tuesday the 17th, you say?
That's when you report down to
Okay, Mr. Davis, are you ready to proceed with Mr. Jacobs?
I am ready. Does the court need a plea form before, or can we place this on the record?
I did just a minute ago get a plea agreement form emailed to me.
You did, okay. I don't see it. My email. Oh, here it is. Please account 1, possession more than 50 to 40. Yep. Okay, it looks correct.
Okay. All right, we are back on the record then in file 24-21919-FH, People versus Andrew Frederick Jacobs. At this point, it's my understanding we're ready to proceed with entry of a plea. Is that correct, Mr. Davis?
That's correct, Judge.
All right, and do you want to, Mr. Davis, state your understanding of the plea agreement? Then I'll ask Mr. McCready to confirm.
Judge, my understanding of the plea agreement is my client is going to plead guilty to count 1, possession with intent to deliver 50 grams, but less than 450 grams of cocaine. There's a sentence agreement of 48 months to 240 months in the Michigan Department of Corrections. All remaining counts will be dismissed.
Is that a complete and accurate statement of the agreement, Mr. McCready?
It is.
Mr. Jacobs, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
Mr. Jacobs, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession with intent to deliver more than 50 grams, but less than 450 grams of cocaine?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 20 years in prison and or a $250,000 fine?
Yes, sir, I do.
Are you satisfied with Mr. Davis and the advice that he's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. McCready?
That is correct.
Mr. Davis?
Yes, it is.
Is that also your understanding, Mr. Jacobs?
Yes, sir, it is.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Jacobs, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about February 6th, 2024, in the city of Adrian, county of Lenawee, that you did commit the offense of delivery or manufacture of cocaine of more than 50 grams, but less than 449 grams?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
You understand that if I accept your plea, you're giving up any claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, sir, I do.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Jacobs to plead guilty?
No, Your Honor.
No, Judge.
Mr. Jacobs, other than as we've discussed it on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
Yes, sir. Well, just what the deal they offered me.
Okay. Nothing, anything
Oh,
different
nothing
than what
else.
we
No, sir.
discussed
No,
here?
sir. Sorry, I'm sorry. I didn't understand. No, sir. Nothing else.
No, that's fine. Okay, I just want to be clear. All right, is it your own choice to plead guilty today?
Yes, sir.
Mr. Davis, do you want to cover the factual basis?
Yes, I do.
Go ahead.
Thank you. All right, Mr. Jacobs, I'll direct your attention to February 6, 2024. We're in the city of Adrian, Lenawee County.
Yes, sir, I was.
And in your possession at your home, do you have more than 50 grams, but less than 450 grams of cocaine?
Yes, sir, I did.
And it was your intent to share that cocaine that was in your possession with another individual. Is that correct?
Yes, sir, it was.
And you don't have a legal right to do so. Is that fair to say?
Yes, sir.
Right, I'm satisfied.
People are satisfied.
Has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Yes.
Mr. Davis?
Yes, you have.
Thank you. And all right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Jacobs has had full knowledge of his rights and he's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as it's been stated on the record here today. I will refer this matter to the probation department for pre-sentence investigation and set sentencing for January 24th at 8:15, if that date works.
Yes, that works.
That's fine, Your Honor.
January 24th at 8:15 a.m. Mr. Jacobs, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Yes, sir, I will.
All right, is there anything else we need to address on the record today?
No, Your Honor.
No, Judge.
All right, thank you then, Mr. Jacobs. You can let the officer with you know that you're done with court for today.
All right, thank you.
Thank you.
Okay, Ms. Underwood, are you ready to proceed?
Mr. McCollum Rosa, yes, Your Honor. Thank you.
Okay. We are on the record then in file 24-21958-FH and 24-22070-FH, People versus Skylar Austin McCollum Rosa. We are here today for a pretrial conference in the 21958 file and an arraignment in the 22070 file. We are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed.
Isaac Sneed for the people.
And Ms. Underwood.
Rhonda Underwood from Mr. McCollum Rosa, Your Honor. As to the arraignment file, Your Honor, we would ask the court to enter a not guilty plea. We would waive the reading and acknowledge the receipt of the information and the witness list and request for discovery. As to all three files, Your Honor, it was my hope that I believe we have a plea bargain worked out. However, we need, I believe, one more pretrial in short order to get everything, get the I's dotted and the T's crossed, Your Honor.
Enter a not guilty plea for Mr. McCollum Rosa in the 22070 file. And we can set a pretrial conference for we can do January 8th at 8:15, Ms. Underwood.
That's great, Your Honor. Thank you.
Okay.
And I'm happy to do the stipulation and order on the two files, Your Honor.
Okay.
With Mr. Sneed's permission.
Okay, so the 22070 file was an arraignment, so we'll enter the not guilty plea. The court will send out a notice on that one, and then Ms. Underwood, if you could do a stip in order on the 21958 file.
We would ask those be set at the same time on the 8th.
Yeah, they're set for the same date. I just need you to do the stip in order in the 21958 file. The court will do the notice in the other one because it was an arraignment.
Okay.
Mr. McCollum Rosa, your next date is January 8th at 8:15. You'll log in using all the same Zoom information that you used today. Do you understand that?
Yes, I understand, Your Honor.
Okay. So you're all set then. You can go ahead and log out.
Could I talk to my attorney for like a quick minute, if possible? I just had a question.
Mr. McCollum Rosa, I will call you. Okay. Thank you.
All right. Sounds good. Thank you.
Right, you can go ahead and log out then.
All righty. Thank you.
All right. And then Ms. Underwood, you're going to go speak to Mr. Bradley right now?
Yes, I believe that will just take a minute, Your Honor.
Okay.
Can I talk to Mr. Sneed for just a second?
Yes.
Right.
Your Honor, in order to do the allocation, I'm gonna have to go get my device.
Okay. See a guy in lockup.
Who?
There's a guy in lockup.
Yeah, go ahead. Yeah.
Okay, we are on the record in files 24-21917-FH and 24-21918-FH, People versus Elijah Tremone Bradley. We're here today for pretrial conferences in both of those cases, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed?
Isaac Sneed for the People.
Rhonda Underwood for Mr. Bradley this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Bradley's case?
Your Honor, we are going to enter into the plea bargain we started the last time. I believe there's a plea agreement in the file. Mr. Bradley will be pleading guilty in file number 2421917FH to count 1, assault of a prison employee, a 5-year felony, and in file 2421918, Your Honor, he will be pleading to count 1 as well, assault of a prison employee, another 5-year felony. The 2421917 file, the habitual offender will be dismissed, and in file 2421918, count 2 and the habitual offender will be dismissed. Mr. Bradley's sentencing will be the lesser of 24 months or the low end of the guidelines to be served within Michigan Department of Corrections. Of course, because this is a crime committed in prison, that will be consecutive to what he is currently serving.
Okay, Mr. Sneed, is that a complete and accurate statement of plea agreement?
Yes, it is, Your Honor. Thank you.
Sir Bradley, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Elijah Tremone Bradley?
Yes, correct.
Mr. Bradley, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty in file 24-21918-FH to count 1, assaulting a corrections officer?
Yes.
Is it also your intention to plead guilty in the other file that's 24-21917-FH to count 1 in that file, also an assault of a prison employee? Do you understand that the maximum possible penalty for each one of those offenses is up to 5 years in prison?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice that she's giving you?
Yes, sir.
Neither the prosecutor or defendant or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Ms. Underwood?
It is, Your Honor.
Is that also your understanding, Mr. Bradley?
Yes, Your Honor.
If a guilty plea is accepted, Mr. Bradley, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have any witnesses that you have. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Bradley, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor. Absolutely.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
You understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about February 4, 2024 in Madison Township, Lenawee County, Michigan, that you did commit the offense of assault of a prison employee?
Yes.
And in file 24-21918-FH, how do you plead to the charge that on or February 3rd, 2024 in Madison Township, Lenawee County, Michigan, that you did commit the offense of assault of a prison employee?
Yes.
Has anybody made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your pleas were given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter those pleas?
Yes, sir.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Bradley to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Bradley, other than as we've talked about it in court here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
Yes.
Anything different than what we've talked about here in court today?
No, Your Honor.
Okay. So the only discussions she's had with you are what we've talked about, that your sentence would be the lesser of 24 months or the low end of the guidelines. Is that correct?
Yes, Your Honor.
Okay. Is it your own choice to plead guilty today?
Yes, Your
Honor. Ms. Underwood, do you want to cover the factual basis?
I'm going to start, since I have it on my screen, with the 1-7 file, Your Honor.
Okay.
Mr. Bradley, on February 4th, 2024, were you an inmate at the Gus Harrison facility in the Township of Madison, County of Lenawee, State of Michigan?
Honor.
Yes.
Yes.
And you were validly incarcerated there?
Yes.
And did you come into contact with the corrections officer, Marlon Munson?
Yes.
And at that time, did you throw a liquid substance from a carton through the food slot at Mr. Munson?
Yes.
And you did that without his permission. He didn't tell you it was okay to do that, correct?
Yes, yes,
And you did that, and you know that's an assault.
yes.
I believe the factual basis is established on that file, Your Honor.
Mr. Sneed, are the people satisfied with the factual basis on the 21917 file?
Yes, Your Honor. Thank you.
Okay.
And Mr. Bradley, on February 3rd, 2024, you were again an inmate at the Gus Harrison facility, Township of Madison, County of Lenawee, State of Michigan, and validly incarcerated there, correct?
Yes.
And on that date and time, you came into contact with Caitlin Bowker, a employee of the facility. I believe she might be the nurse.
Then we count as Adrian.
I'm sorry?
Is it Adrian?
Yes.
I never did that.
Okay. And do you recall throwing a apple juice container at a woman at the facility?
No.
Okay. Do you one moment, Your Honor. Okay. Ms. Bowker was the nurse passing out meds. Do you recall that?
I don't even know who that is. The only person I dressed out was the officer and the inmate.
The officer, I'm sorry. There was a person with the officer.
It was the inmate.
This is the nurse. It's a woman. Do you recall her?
No, I don't even know who you're talking about.
I'm going to ask permission from the prosecutor if we could perhaps do the second count, which is to the corrections officer, rather than the first count. Mr. Sneed.
Yeah, I have no objection to that, or if the court would allow changing it to a no contest to count one based upon civil liability.
Well, he's only pleading guilty to one count. Yeah.
All right, so are you saying, Ms. Underwood, that he has a memory of the incident that relates to count 2?
Right. Do you recall Corporal Washburn throwing apple juice and striking him?
Is the inmate?
No,
Oh.
he's an officer, Corporal Washburn.
I'm not familiar with that name.
Okay. You threw liquid on the guards 2 days in a row.
What was that?
Adrian,
Yes.
do you recall the first day?
Yeah.
And you threw liquid at a guard.
The water.
Was it water? We don't know. If you say it was water, it was water. You threw that at the guard, correct?
Yes.
And the guard gave you Corporal Washburn, and he gave you no permission to throw that, correct?
I was arguing with him. He got upset. So I was dressed him up.
Okay. So you didn't have permission to do that, correct? And that's an assault, correct?
Yes.
I believe the factual basis has been established, Your Honor.
All right, and Mr. Bradley, the incident that you were just talking about, did that occur on February 3rd, 2024?
Yes, Your Honor.
Okay. Mr. Sneed, are the people satisfied with factual basis in the 21918 file?
I am, Your Honor, and my understanding is the court's accepting the plea to count 2 on file ending 18 FH instead of count 1.
Correct. Count 2.
Yeah, I just want to make sure that's clear for our Nolly Proseque. Thank you.
Yeah, so that's count 2 instead of count 1 for that file.
Thank you.
Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, thank you.
Ms. Underwood?
It has, Your Honor.
All right, I will accept those pleas, then they have been given understandably, voluntarily, and accurately. Mr. Bradley has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for an update or for a pre-sentence investigation and set sentencing for January 30th at 8:15 a.m. Mr. Bradley, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background. You do have a right, Mr. Bradley, because it's a sentencing in a felony case, you have a right to be present in person in the courtroom for your sentencing hearing. If you don't want to exercise that right, if you want to waive that right to be here in person, you can also do it by Zoom. It's completely your choice. Do you know how you'd like to appear in court, whether you want to be here in person or by the video conference?
I understand what you're saying, Your Honor. You said something about probation officer.
Yeah, someone from the probation office is going to do a pre-sentence investigation. And so they're going to contact you to do an interview to do that.
Why is that when I just plead guilty?
Because every time someone pleads guilty to a felony offense, the court has to have a pre-sentence investigation prepared. And a part of doing that pre-sentence investigation is to have the probation officer contact you, and you can make a statement if you like.
Prison, he says probation.
Right. They're prepared by probation officers. It doesn't mean you're going on probation.
Yes, I understand.
Do you want to be here in person or do you want to be sentenced by Zoom, Mr. Bradley? Zoom? Zoom is fine, Your Honor.
Okay, so we'll set that up for a video conference, a Zoom hearing.
Your Honor?
Yes.
Can you find out what prison he's currently incarcerated at, please?
Are you still at Gus Harrison?
No.
Where are you now?
I'm at.
Okay.
Thank you.
All right, so we're all set for today then. We will see you back for your sentencing hearing, Mr. Bradley.
Thank you.
I believe that concludes my docket this morning, Your Honor.
Okay, if it does, I have some violation of probation summons, but nobody has shown up on it.
I got 5 minutes.
Okay.
Well, good morning, Judge.
Thank you, Mr. Sneed. All right, we are on the record in file 23-21242-FH People versus Brandon Lorenz Joe Madison. We're here today for a hearing on a summons for probation violation. We are proceeding today in person. The courtroom is open to the public, also by video conference. The court does have a video conference session running. The record should reflect that Mr. Madison was ordered to appear here today at 8:15 a.m. for a show cause hearing related to a probation violation. It is now 10:41. Mr. Madison has not appeared either by video conference or by being present in the courtroom. I am going to issue a bench warrant for his arrest and set bond on that bench warrant in the amount of $25,000. Next, we are on the record in file 22-20797-FH People versus David Raymond Gilbert. We are here today for a hearing on a summons for probation violation. Record to reflect that Mr. Gilbert was ordered to appear here this morning at 8:15 a.m. to respond to alleged probation violations. It is now 10:42 a.m. Mr. Gilbert has failed to appear. He's not present in the courtroom. He has not logged into the Zoom session. We're going to issue a bench warrant for his arrest and set bond on that bench warrant in the amount of $25 cash portion. We're on the record file 24-21974-FH People versus Aaron Michael Bauer. The record should reflect this matter was set for a summons for probation violation hearing this morning at 8:15. Mr. Bauer was ordered to appear. It is now 10:42 and he has failed to appear. I am going to issue a bench warrant for his arrest and set bond on the bench warrant in the amount of $25,000 cash or actually, Ms. Holly, this was a failure to pay child support charge. Do you know what the current outstanding amount of support is?
I don't. I was afraid you were going to ask me that. I don't. I can look into that. Oh, you want to know for the bond?
Yeah, I'll just leave it at $25,000
right.
cash surety then.
All right. Thank you.
Okay. Thank you then. I think we're all set.
Thank you, Judge. Have a good day.
You too.